So good afternoon. We're going to give this just a couple of seconds while people join the webinar, and then we will go ahead and get started. All right, we will go ahead and get started. Good afternoon and welcome. Thank you for joining us. This is 5 years of the Friday Five, and we are going to talk about recurring themes and emerging trends in ERISA litigation. My name is Amy Kline. I'm a partner in Saul Ewing's ERISA litigation group based in Philadelphia. I'm joined today by two of my partners, Caitlin Strauss, who's also in our Philadelphia office, and Mike Joyce, who's in our Pittsburgh office. They are both partners, and Caitlin is the lead of our ERISA litigation group. Together, we make up the editorial team of Saul Ewing's Friday Five. So before we begin, a few housekeeping comments. There is a Q&A button at the bottom of your screen. Questions can be submitted through the Q&A tool. We will do our best to answer any questions as they're raised or by the end of the webinar. If for some reason we don't get to your question, we will certainly circle back with you. The Q&A button is different from the chat button, so that if you submit a question via the Q&A, it will not go to everyone, it will just go to us. Importantly, this program has been approved for CLE, one substantive CLE credit in California, Delaware, Florida, Illinois, Minnesota, New Jersey, New York, Pennsylvania, and Rhode Island, with applications pending in Maine, Tennessee, and Virginia. As I'm sure you're all familiar with webinar CLEs, we have to confirm your attendance and participation, and we do that by the two numeric codes that we will announce over the course of the CLE. I ask you to write those down, because then you'll need to include those two codes in the survey that you'll have to complete at the end of this process so that you may receive CLE credit. You're going to get an email with a link to that survey. We ask that you respond with those codes within 5 days of the program. The webinar is being recorded, as you likely saw. Following the webinar, you will receive an email that includes links to the webinar recording and includes the presentation materials. And last but not least, of course, the provision and receipt of information in this program, of course, is not legal advice. It does not create a lawyer-client relationship and should not be acted upon without seeking professional counsel who have been informed of the specific facts. And so with all of that, let's begin. Next slide, please. So, what is the Friday Five? Hopefully you're familiar. Hopefully it's why you're here. But 5 years ago, roughly, we started a publication that was intended to be a review of 5 significant cases from that month in the ERISA litigation space. Now, more than 300 cases later, we did a retrospective review of those cases and of those summaries, with the goal of identifying themes and emerging trends from those cases in ERISA litigation. Our purpose today, and in keeping with the theme, is to discuss 5 of those themes. Next slide, please. So the 5 themes and/or trends that we identified are recoupment of benefits, standard of review, trends in the types of claims, what we expected versus what we saw, and new theories and trends. Next slide, please. So I get to kick things off by talking about recoupment of benefits and overpayment. And I'm going to talk about 3 cases that were noteworthy on the issue of recoupment of benefits. The first is Morris versus Aetna, that came out of the Central District of California in 2021. There we have some subsequent history that we can talk about too that came out after we reported on the case in 2021. But the facts generally are as follows. The claimant's long-term disability plan had a benefit that was 60% of the insured's monthly pre-disability earnings, less applicable offsets. And the terms of the plan very clearly allowed the insurer to recover overpayments. Here, the claimant was approved originally for ONOC benefits and then NEOC benefits. But in calculating her benefits, there was an error. It was premised on the idea that she was paid 26 times a year, when in reality she was paid 24 times a year, the effect of which was to overstate her income and therefore overstate her benefit amount. That is a miscalculation that persisted from roughly 2011 until 2019. And in 2019, it was discovered that this miscalculation had been in place, and there was an effort to recoup approximately $56,000 in overpayments. Following an appeal and denial of that appeal, the claimant filed a lawsuit in the the Central District of California. The district court dismissed the claim, and there were two claims that had been brought, one of which was a claim under 502A1B. And the court dismissed that claim and said that under the very clear terms of the plan, she was not entitled to the benefits that she sought. It was a pure mathematical calculation based on her income and then 60%. She also brought a claim, though, under 502A3 for breach of fiduciary duty. And there, the Central District of California said that no claim had been stated based on a Ninth Circuit's case, essentially, that said that the non-discretionary application of a preset formula for benefits did not constitute a fiduciary action. And so without a fiduciary action, there was and could be no breach of fiduciary duty. The claimant appealed, and in front of the Ninth Circuit, roughly 2 years later, the Ninth Circuit actually reversed on the breach of fiduciary duty claim. And I would say that driving the Ninth Circuit's decision wasn't so much the miscalculation as what it perceived to be discretionary acts in dealing with the claimant. And those are its words. So during the 2011 to 2019 time period, the claimant reportedly sought and received confirmation of her benefit amount and was able to articulate that she had relied on the confirmation that the benefit amount was correct in connection with a mortgage application, preparing her taxes, a divorce, arbitration, et cetera. And so the court really focused on what I expect was a very unique and distinguishable series of facts, and said that it was in communicating and affirmatively telling the claimant that her benefit amounts were correct, that the fiduciary obligation arose and the fiduciary obligation was breached. So the case is noteworthy, obviously, in that it allowed this breach of fiduciary duty claim to go forward. But at the same time, like I said, the driver really does seem to be some pretty unique facts. I think it's fair to say that it did not change the law, at least in the Ninth Circuit, that the calculations and the application of a preset formula is not going to amount to a fiduciary function, so that a miscalculation itself is not going to give rise by itself to a claim for breach of fiduciary duty. The second case that I'm going to talk about is a case, and next slide, please. This is a case that comes out of the Northern District of Illinois, and I will briefly editorialize and say that it was written by Judge Seeger, who, if you have not been in front of, I would describe him as blunt and conversational in the way that he writes. And so I think that you can see that in the opinion. And when I use some of the language, it appears to create sort of an interesting standard, but I actually think it is more a function of the way that he writes his opinions and not actually creating any new law there. So here, the plaintiff, or I guess the plaintiff was the estate of Mr. Stewart. He was involved in a pension plan where he received monthly payments. At some point, the decision was made that the monthly payments would be paid out in a prospective looking lump sum amount. The claimant elected the lump sum payment, but before it was effected, he passed away. The lump sum payment check was paid, however, because unbeknownst to the insurer or the company, the plan, they did not know that he had passed away. The check was canceled once they learned of that information. And so the estate filed a lawsuit claiming that the cancellation of the check was improper. So here, the judge first looked at the standard of review, and he found that because the plan granted full discretion to the plan administrator, that the way that he was going to articulate the issue to be decided was whether a reasonable jury could find that the decision to deny the benefit was, quote, downright unreasonable, which is a phrase that I am not otherwise familiar with in the breach of, the abuse of discretion context. But I think what he was communicating, again, was an abuse of discretion standard using this sort of more colloquial language. The court granted the plan's motion for summary judgment, and the plan had argued essentially two things. One, that the language of an amendment, which allowed the lump sum payment, precluded eligibility for those people who had died before the date of the effective date of the lump sum payment. There was some question as to whether the decedent had elected that lump sum before the eligibility amendment came into effect. So the court didn't end up deciding it on that language. He decided it on a much more sort of organic and fundamental fairness principle. He granted the motion saying that the lump sum payment was prospective. And just as a matter of fundamental understanding, the member was not entitled to a lump sum payment for when he wasn't alive on the day that the lump sum payment would be accounted for when it was on a prospective basis. So if he died in mid-March and the lump sum payment was going to pay him for benefits from April on, of course he wouldn't be entitled to benefits because he wasn't alive on that April 1st date. Next slide, please. Last case that I'm going to discuss is a case from Chief Judge Brand out of the Middle District of Pennsylvania, Wolf versus Aetna. And this was a putative class action arising from an individual who was injured in a car accident. She received benefits under her long-term disability plan. And she also was able to sue and recover a settlement from the other party to the accident. Under the terms of the plan, reimbursement was sought for the benefits that were paid because she had received this other income on the settlement. And she challenged whether personal injury recoveries were included within the definition of other income benefits. Judge Brand granted the motion for class certification. And I won't go through the entire class cert analysis, except to say that there wasn't really a ton of question in his mind when you read through the opinion that the requirements under 23A and 23B were satisfied. After there was a motion for reconsideration, and Judge Brand actually granted that part and denied it in part. The argument on the motion for reconsideration was that there had been an intervening change in the law based on a Third Circuit decision. And while Judge Brand said that that in fact was not an intervening change in the law and that class certification was appropriate, he did agree to modify the definition of the class, having determined that as originally defined, it was a fail-safe class, meaning that membership depended on whether a potential member had a valid claim. So the modification on reconsideration was to the definition, but not to the class certification more broadly. I will note that a motion to stay pending appeal was filed in that case, which Judge Brand also denied. And the current procedural posture of the case is that it is stayed based on a joint motion, presumably to discuss settlement. So an interesting one in the sense that some of the arguments that were made was that this couldn't be a class action because the plan language varied. And Judge Brand was convinced that while there were differences in the plan language, the actual language that was the focus, which was this definition of other income benefits, was materially similar so that it was appropriate for class certification. I'm now going to hand this off to Mike Joyce to talk about issue number 2, which is the standard of review. Take it away, Mike.
Thanks, Amy. Hi, everybody. I know we have different levels of experience with ERISA litigation on the call, but I thought I'd set the stage a little bit, just do a quick basic overview of the standards of review. And the interesting thing about ERISA is it says a lot of things, but it doesn't say a word about the actual standard of review the court's supposed to use to review a benefits decision on appeal into federal court. And so the courts have developed 2 different standards. The default standard is de novo, and so that's when the court gives no weight to the administrator's decision and can make its own decision. And sometimes that's the court accepting the decision below and the rationale. Sometimes the court comes up with its own rationale, and then other times that decision might just be rejected altogether. And so, as you can imagine, this is normally the standard that the plaintiffs really want in the cases, and some plaintiffs push it from the get-go. The second, which is the one that we're often in the position of advocating for, is the arbitrary and capricious standard of review. And that's when the plan documents, that's the trigger for the standard. Those documents provide discretion to the administrator to review claims for benefits, review plan language, interpret the plan, things like that. And that provides, some of the nice language that Amy had in the case that she presented. It's only overturned if it's unreasonable, unsupported by evidence, erroneous, things like that. And most plans include that type of language now. So this is frequently, not only the standard that we're arguing for, but a lot of times the one that we're able to have applied in the case. A question we get a lot is, how is the standard review set in a case? And it depends. There's 3 areas where it normally comes up. Some opposing counsels actually consent to the arbitrary and capricious standard review. Sometimes it's in the complaint, which makes it very easy. Easy for us, easy on the court. There's no dispute. And you see that a lot of times when the plan documents are very clear on the situation, and you also have sort of a normal administrative process, no issues with it. Or sometimes it's possible the opposing counsel just doesn't want to fight it. We see that once in a while as well. The second area is sometimes it's determined during the summary judgment process, which can be a bit difficult because then you're devoting a lot of briefing to the standard of review and what documents need to inform it and things like that. And it's really, a separate issue that's briefed alongside the summary judgment issues. And then other times you see it somewhere in between. So a lot of judges will have it, either within a discovery battle, or you might even have a briefing schedule of, hey, we're going to figure out the standard of review before mediation because it matters for the negotiation, or before summary judgment, whatever the case is. And I did a quick, why does the standard review matter and why does it not? And why it matters is, substantively, it's the standard review for the administrator's decision. And then procedurally, it could impact things like discovery. Why it doesn't matter, this is, I think, unfortunately, the jaded litigator in me, so you don't have to take this advice, but there's 2 reasons why sometimes it just doesn't feel like it matters. Opposing lawyers often don't take it into account when they're figuring out a settlement demand. To them, it's just math, and you get the demand for the full benefits, which is an experience in some of these cases. And then other times, the application of the standard review can be very specific to every judge. Even though the standards are so well settled, the way the judges treat them is always interesting. You see some judges that for some reason they catch something in the administrative process and really, really dislike it. And they latch onto that, and you end up getting sort of a wacky ruling at the end of the day in a situation that maybe the administrator should get some leeway, but you don't get that benefit for whatever reason. One other issue before we get into the cases, there's some unique issues or twists on the standard of review that have come up more recently. The first is that some jurisdictions, and I'm thinking of Texas right now because I just dealt with it, they've actually enacted state bans on discretionary provisions in insurance policies. And so you have the states using their power to control the insurance industry within its borders, and trying to give ultimately claimants sort of a leg up in these cases when they get to court. The nice thing is that a lot of courts have been resistant to those bans. There's a good case in Texas that refused to apply that ban to self-insured plans, saying, that the language that in the statute only applies to insurance policies. Self-insured policies ultimately don't rely on an insurance policy to support them, so it doesn't apply. And of course, there's been battles, although I don't think it's been decided, about whether ERISA might preempt some of that state law. And the second, again, when you have the plans so frequently using the discretionary language, lawyers, plaintiffs now are getting a little more creative on how they attack the standard of review. And there's law that if there's certain missteps, particularly significant ones, during the administrative process, that the administrator ultimately won't get the benefit of that heightened standard review. On the next slide, we line up what trends we've seen from the de novo cases throughout the years. And of course, the Friday Five, we've hit the highlights. We've tried to find the interesting cases. And so this isn't we didn't capture all the standard review cases, just the ones that we found interesting and meaningful. But what you'll see, I think, at the beginning, the takeaway is just because the de novo standard review applies doesn't necessarily mean one side or the other wins. And I don't think it's necessarily an even split, but again, de novo doesn't mean the administrator automatically ends. We have two cases highlighted for when the carrier prevailed. The first one is the Shake case. That's a Northern District of California case in 2019. And that was a standard review where the court actually refused to allow discovery into an issue we often see in these cases, which is sort of the statistics of medical reviewers involved in the administrative process. And so the plaintiff there asked for all sorts of information about how many claims were reviewed, the compensation scheme, the hours devoted to reviews, things like that. And the court looked at it and said, look, we understand that the de novo standard applies, and there might be some additional leeway to allow discovery, but this doesn't feel like a unique situation. There's not enough facts to support the need for discovery. And the interesting thing that the court said, which I'm not sure I agree with, is the court said, the issue for us is whether the decision was right or wrong, not necessarily why it might be wrong. Although, again, I think why the administrator might have messed up or not is often the key issue, but not to this court. And ultimately, the takeaway is, even under de novo, you still have some courts, some judges on the right record that remain protective of the administrators. The next case is Bruner. That's a Fifth Circuit case from June of 2022. And the Fifth Circuit there affirmed the district court's refusal to find a waiver or estoppel issue. It was an interesting scenario where the employer explained to the employee, at least for purposes of short-term disability, that they wouldn't enforce a pre-existing condition limitation. And so the employee sort of took that discussion and ran with it, and then tried to apply that, we won't use the exception onto the long-term disability claim. And the court ultimately found there that it had a very easy time applying the pre-existing condition limitation to LTD and not really stretching that conversation to all benefits. And again, the takeaway is, I think in these more mechanical cases, when you have a clear policy provision, clear exception or something like that, there's no reason to be worried about the de novo standard. On the other side there, we have the cases where the claimant prevailed. And the first is the Holmgren case, which is the Northern District of California in 2019. And in that case, the parties actually agreed to the de novo standard. And if you read the opinion, the court really, really hits the administrator hard on certain issues that I think we've seen, sort of run-of-the-mill approved in other cases. For example, there was an allegation that the administrator favored the consultant's opinions over examining physicians, and the court really went after the administrator on that and a couple of other points. And ultimately, this case, I think, shows the dangers of de novo, and sometimes why we can be worried about it is that the court is ultimately given a lot more leeway define certain issues it might be unhappy about, and then find that as a reason to reverse the benefits decision. The other one is Counts. That's Eastern District of Michigan from 2020. And in that case, the de novo standard was actually imposed because Colorado, which was the applicable law, has one of those nice statutes that prohibits discretionary clauses. So the court had no qualms about imposing the standard there and not respecting the grant of discretion that was in the plan documents. And interestingly, the court there actually allowed affidavits, so new affidavits that were created for purposes of litigation from treating physicians of the plaintiff with new information about the treatment and what they thought about the treatment and plaintiff's status. And so I think Counts is a little bit of a warning sign again of how far courts might go under the de novo standard. A physician writing an affidavit during litigation, presumably prompted by counsel or the patient as to what needs to be in there, is a much more different scenario than things that might be submitted in the normal course in medical records during treatment. On the next slide, we move to the other side of the coin, the arbitrary capricious standard, and what we've seen over the years. And while we do have one more case on the carrier prevailed side, oh, I guess it's just bigger font, sorry. No, so we have a tie, but again, the takeaway is the flip side of de novo. It's just because arbitrary and capricious standard applies doesn't necessarily mean carrier prevails. On two of the cases where the carrier prevailed, Miller was an Eighth Circuit case from 2019, and that's sort of a classic enforcement of the heightened standard of review. The court really refused to even get past the point after we see a meaningful review and we think there's some evidence there. The court stopped at that point. They said the review's enough. We don't see any major issue with it. There's some evidence to support the administrator's decision. It didn't want to get into the weeds and ultimately had no problem approving the administrator's decision. It also felt like the court just wanted to get rid of the case, which can sometimes be very helpful. There were some other claims in there that the court very quickly kicked back to state court, didn't want to even talk about them in the opinion. The other on the carrier prevailed side is Cantor. So that's a Northern District of Illinois case from February of 2021. That's sort of in the middle ground. The court there concluded that the benefits termination, quote, survived the deferential review. And so this is an example of when the standard review really mattered. The court wasn't overly thrilled with the administrative process and how the decision was supported, but it applied the standard review, said, we don't agree with it, but it's enough, and ultimately supported the administrator in that case. On the other side of the slide here are the claimant prevailed cases. And the first one's Riccardi, that's Southern District in New York from 2019. And there, the court really, and it's a great opinion. If you want to read it, the language is fantastic, but the court blasted the administrator for ignoring evidence related to the calculation of benefits. So for some reason, the way this individual was paid through bonuses and from some other comp, whatever documents were given to the administrator showed like 1/8 of the pay that should actually be used for calculation. The court was very unhappy with it. And my favorite line was, "Nothing in this record makes any sense," which is ultimately, it's a heavy statement from a court at any point. But, if you think about the posture, the court has the entire administrative record in front of it. It's had briefing on the issue, it's had argument, and it still had no idea what was happening in the record. So it must have been an absolute mess. And that quote also took us into quotes from Alice in Wonderland and all these other stories. And so a wonderful little opinion, but ultimately that case shows us that the arbitrary and capricious standard review might not matter as much when you have real problems in the underlying administrative process. You're not going to get the benefit of it from the court, especially if none of it makes sense. And the last case I'm going to talk about is Dimry, which is a Ninth Circuit case from 2021. There, the court refused to defer to the administrator because, again, there were issues in the administrative process. It was mentioned that the claimant was completely unaware of what was happening, was wholly in the dark as to the process, where it was, the reviews that were taking place. And the court went as far as say, we don't even want to remand it back to the administrator because the process was done so poorly. it actually instructed the district court to make the benefits decision on a remand to the court. And again, this is an example of times when the arbitrary and capricious standard of review should apply based on the documents, but you lose the benefits because of those missteps during the administrative process. The next section on the next slide here is trends in the types of claims that we see. And again, I think the moral of the story that you'll see here is that the plaintiffs' lawyers, the claimants, are getting more and more creative in the ways they try to increase the value of cases, increase risk to the insurers and the administrators. I think it's become exceedingly rare now that we just sort of see a regular single claim benefits complaint that says, I satisfied the benefit standard review and you administrator messed up. For the most part, there's always something else in there. The next slide shows us sort of the first sub-trend we've seen within these types of claims. And at least to us, again, we didn't pull every single case, but at least the more interesting ones, there's a lot more white collar occupations that we've seen recently. I think that's interesting to people because when you talk about the disability claims, a lot of folks who aren't in the industry sort of look at it like a workers' comp claim, and they assume it's a blue collar worker who's doing manual labor, gets hurt at work and goes on disability. But again, what we've seen is certainly an increase in the white collar claims. And if I had to guess why, it's probably for two reasons. First, the white collar workers generally earn more. So that means you have a larger dispute over benefits, and the plaintiff or even the defendant are more likely to carry that case further and fight it more. So you get more opinions generated on issues of the standard of review and discovery and ultimately summary judgment. So it might just be an availability issue. And the other part is a lot of times you'll get into more nuanced issues depending on the type of work, if it's just a desk job, things like that, as to how the disability plays out versus if you have a more manual blue collar occupation that might be a little clearer whether somebody can do it. The next trend that we see on the next slide here is that we're continuing to see procedural irregularities pleaded with frequency, and each really has its own unique little story. The first one here is the Hoffman case, and that's from the Ninth Circuit in 2019. There, the circuit court remanded back to the district court because it was frustrated that the trial court did not address every procedural irregularity that was raised by the plaintiff. And the interesting thing, it was sort of the classic irregularities that we hear about during the administrative process itself, but the Ninth Circuit was also upset with some what were really irregularities during the litigation. And so, for example, when the administrative record was produced, certain documents were missing. And so the courts, presumably argued by the parties originally, but the courts used that to reflect badly on the administrative process itself, saying, we don't know if these documents were in the record because they weren't produced correctly, things like that. So an interesting situation where conduct in litigation can actually be carried all the way back to reflect poorly on what happened during the administrative process. On the next slide, we have a District of Arizona case, and we'll stay with the District of Arizona for two cases. The first is Woosley, which was from 2020, and that case focused on the irregular communications between the administrator and the claimant. During the short-term disability case, the back and forth was great. When the LTD claim came along, was not as great. And the line that I think caught me the most was the court said that there should have been specific feedback to explain deficiencies in the claim. That's certainly a higher standard than I've seen before, and blurs the line between the administrator and the fiduciary duties and what needs to be provided to the claimant. The second is Yohal. That's the District of Arizona again, back in 2020, and that district continues to make it difficult for us. But here, the court allowed the plaintiff to submit an affidavit explaining basically that the claims manager walled her into believing that she shouldn't or couldn't provide information on appeal. So the administrator said, hey, we have enough to make a decision. And the claimant took that as, okay, you don't need anything and I'm going to get a decision in my favor. And so the court bought that explanation and ultimately allowed the record to be supplemented. On the next slide, we have one of the more unique irregularities that I've seen. It's the Doe case from the Middle District of Florida, way back in 2018. And in this case, and I think it's the only one I've seen like this, but there was a large window envelope from the health insurer, and the letter and the information inside sort of shifted. And so some of the substantive letter was actually viewable through the little clear window, and it revealed ultimately this individual's HIV status. And the plaintiff said, hey, I kept this secret from everybody, my family, and this sat on the table at my home, and I have family members, they must have seen it, postal workers might have seen it. And here, normally the courts are very quick to kick non-ERISA claims in these sort of ERISA cases. The court said this invasion of privacy claim is completely distinct, and we have no problem letting it hang around. Up next, and Amy mentioned it briefly through some of her cases, we're continuing to see these A3 claims, which is a breach of fiduciary duty claim. There's a split among the courts, and it's really decision by decision whether one of these A3 equitable claims will be able to survive next to a benefits claim. And a lot of times, and you'll see it through these cases, whether it's Brendy or Blackburn, that the plaintiffs are getting better at showing this separate and distinct injury, and ultimately moving the equitable claim away from the benefits claim and trying to make those survive. And to wrap it up here, on the last slide, we have class actions. And again, when we're dealing with issues of trying to increase the value of cases, the class action is sort of the big way to do it. In a lot of the ERISA cases, particularly the benefits cases, it's tough because you have individualized issues of how the injury occurred and how the administrative process occurred. But in Medical Society of New York, with a Southern District of New York case from back in 2019, the court sort of split things there and was okay allowing a declaratory judgment and an injunctive claim to go forward on certification, but said for the actual award of benefits claims, so the monetary claims, that it didn't want to dig into the language of separate plans, that even though that plan language was similar, wasn't identical, it refused to dig all the way in and make an individual determination. So for that case, at least on the monetary side, there was no class certification. With that, I will turn it over to Caitlin to talk about some more trends about what we thought we saw versus what we did.
Thank you, Mike, and thank you, everyone. I can see on my screen all of our participants, and I see many familiar faces, and I thank you all for being with us on this lovely sunny afternoon in Philadelphia. First, I'm going to start with a very important piece of information. The first CLE code, which is 53211. Again, you want to write that down because you'll need it to get CLE credit. It is 53211. All righty. Next slide, please. So I'm going to cover two topics, and you're going to hear some overlap, which just means that these are definitely theories and trends that we think are things that you need to be paying attention to, because they are themes that have come up from what you heard from Amy and from what you heard from Mike. And a lot of that's going to do with some of the occupations we've seen, as well as the impact or lack thereof of the standard of review. And a preview for the end of this, just to give you a highlight, the issue of subjective versus objective conditions is going to be a big one for me. Okay, next slide, please. Oh, sorry, back one more, sorry. So what we expected versus what we saw, claims involving the 2018 Department of Labor regulatory updates. And this is something, it's hard to believe that I spoke about this in 2018. It feels like yesterday, and spoke again about it a few years later, when there was a lot of concern that the new regulations were going to really change the landscape of what we saw in disability cases, specifically plaintiffs' counsel rushing to the courthouse for cases that they were going to say were deemed denied, or an increase in cases where we saw discretionary review stripped from carriers. And this slide, I only have one, which is why I went too fast over it. There's just not a lot of these cases. So I expected to see a bunch of cases and have a lot to tell you about this slide. But the truth is there's not too much in this area. And actually the two cases that we have from the Seventh Circuit and from the Eastern District of Missouri both focus less on more of the substance of the new regulations and more on just whether they applied or didn't apply based on the date of a claim and the application of the rule changes. So not a lot of news there. So it's just going to be one slide for what we expected versus what we saw. Next slide, please. 2018, when we were talking about DOL regulations, I can assure you I had never heard the word COVID, and probably most of us hadn't. So what we expected versus what we saw when we started the Friday 5 years ago was certainly not COVID. But what we saw was definitely claims involving COVID, which have taken different forms as we go through the stages of the pandemic. And what we saw, at least in the early stages, was a theme of access, which all of us experience just in our everyday lives, right? Difficulty in accessing care when doctors' offices were closed in the early days of the pandemic, not being able to get medical records as part of claims, or also just having the claimants be able to actually see physicians. So a lack of medical records or visits that were performed entirely remotely, which can be difficult when you're dealing with some subjective conditions. And what we've also seen in some of these cases is a remand to claims administrators, especially, as I said, in the early days where either a claim wasn't fully developed because there's a lack of records or because a claimant couldn't get care because of the pandemic. At least in one case I remember there was also the fear of contracting COVID. So there was one claimant who was concerned about going for an IME because he feared that his condition was such that he didn't want to expose himself to COVID if he went for an IME, which resulted in lots of years of litigation. And then ultimately at the end, it just got remanded for a time when things had changed and there was more testing and people could go out into the world without that fear. Next slide, please. One of the other cases where we saw this is the Carney case out of Michigan. And again, this is reference to an inability to access care, which was a fact considered by the court in reviewing what the administrator considered in whether to determine if the plaintiff was disabled. The fact that, at least in this case, part of the treatment was rendered, or lack of treatment, I should say, in the early days of the pandemic when COVID was a concern, was a fact that the court highlighted. As we get years out from the 2020, 2021 time period, I think this sort of trend of difficulty with access to care or records is starting to subside. This was the only case that we've had reported in the Friday 5 that focused on this theme. Next slide. This is going to be a longer series of slides. Long COVID, long COVID, long slides. This is definitely something that I didn't expect to see, but we are starting to see. And unfortunately, it's something that I think we will continue to see as time goes on. And hopefully we will just for the sake of humanity, have better treatments for this, separate and apart from the impact on disability claims. One of the most interesting cases that we covered in the Friday 5 is the Abrams case out of the Western District of Washington. And going to the theme that Mike talked about earlier about occupations, this case involves a litigation partner who is the plaintiff, which I found interesting, and also a marathon runner. So somebody that has a grueling job. There was details in the records about he was preparing, I think he was an IP litigator, preparing for trial and working 10, 12 hours a day, and also a marathon runner. So somebody that you would expect to be in relatively good health. And he started experiencing fatigue, fogginess. Again, we're talking early days of the pandemic. So April 2020, before there was adequate testing and people were necessarily being diagnosed with COVID. It was just presumed COVID. He filed an LTD claim and it was denied because it was found that he didn't support disability throughout the elimination period. Next slide. So again, I mentioned that this plaintiff was a litigation partner, and I say that because this record, I believe, was over 900 pages that he submitted as part of his appeal. It included detailed affidavits from colleagues talking about his occupation and what he could do and couldn't do after his suffering from COVID. And he got the diagnosis of long COVID and also chronic fatigue syndrome. And while the insurer challenged that the diagnoses, the court said, well, you may be right on that, noting the fact that there was a lack of evidence to support these diagnoses. But the court recognized that that wasn't what the court's job was, right? The question before the court was whether the plaintiff had met his burden of establishing disability. And again, we're talking about a 900-page record of claims, and the court found that he had. Next slide. And these are just a few of the interesting quotes that I thought came out of this case. That, again, this may be somewhat of a unique situation, but certainly long COVID is, in terms of the plaintiff and their occupation, but long COVID is not going to be a unique situation for claims that we'll see in this space. And the court said, if plaintiff cannot follow movie plots and suffers daily fevers, he cannot be expected to plan out trial strategies for multiple complex cases. And the court was persuaded by the fact that this plaintiff had depleted his savings and was essentially homebound, and ultimately finding that he was disabled. Next slide. So on the positive side, for the insurance company, although the court did find that the plaintiff was disabled, it denied the bad faith claim and noted that there was a lack of evidence that the plaintiff did indeed suffer or suffers from COVID. And again, this may be somewhat unique because he was suffering from these symptoms in the early days of the pandemic. Next slide. So long COVID, what next? These are two questions that came to my mind as we look at the issue of long COVID. Is this going to be something that we see specifically identified in policies? I don't have a solid answer. I can't entirely predict the future as much as I wish I could, but my gut is no. Will long COVID be subject to similar self-reported symptoms, mental illness limitations? That's an interesting one, and that's going to bleed into the next series of cases I'm going to talk about, which focuses on mental illness cases, subjective, quote, subjective conditions, and that may be something we see. Next slide. So you're going to get a preview, and hopefully you will still want to read our next edition of the Friday Five, which will come out in a few weeks, on a case that I find pretty striking out of the Eastern District of Pennsylvania, which is my home territory, that involves not long COVID, but a related issue of the, quote, subjective condition. And this is the Lewis versus Hartford case, which is, again, out of the Eastern District of Pennsylvania. And I have a number of slides up here that go into detail about the case, which I'm not going to read through in their entirety, but you have it for reference since you can view it on your computers, and we'll be sure to get you guys the slides after the presentation. But back to the Lewis case. So this one is interesting in that it involves a claimant with fibromyalgia. And from my review of the docket, it looked like it started out as a relatively routine long-term disability case, standard complaint, dispute. Looked like there were some efforts to try and settle the case that apparently were not successful. Ultimately, there were summary judgment briefs filed by both sides and oral argument. The judge, who is a senior judge in Philadelphia, had given a list of questions to counsel to review in preparation for oral argument on summary judgment, and then followed up after the summary judgment argument with a request for supplemental briefing on the issue of how to address subjective conditions, quote, subjective, and pain cases. Oh, there we go. My lights went out. Sorry. And ultimately, what wound up happening after oral argument, next slide, is the judge, what seemed to be on his own accord, issued a order that the insurer send the plaintiff for a review of records by an independent physician who was not some sort of an acquaintance of the judge, is what the judge wrote in his opinion, which struck me as, again, a little bit unusual. And the judge acknowledged that this was an unusual circumstance in this case, but that he was nonetheless going to order this independent physician to do a medical records review and ultimately a IME of the plaintiff. Now, remember, this is after summary judgment briefing. This is not part of the record. This is all the judge's decision. Not surprisingly, Hartford challenged that decision and filed an appeal to the Third Circuit. There was an opinion written by the district judge as part of the request for the Third Circuit for a writ of mandamus. And ultimately, at the end of the day, the Third Circuit denied the writ, but seemed to try to level set things back to what I think most of us are familiar with, not having IMEs ordered by judges at the conclusion of cases, and ultimately said, based on the record and what the judge had said in his opinion, that he could have remanded the claim back to Hartford. The court suggested that, the Third Circuit that is, suggested that the district court in fact do that. And ultimately on remand, next slide. And next slide, sorry, one more. Ultimately on remand, the court did take the suggestion but also suggested to the carrier, in his opinion on remand to the carrier, that an IME be done with a quote pain specialist. So this case is not a claim involving COVID, but it's certainly timely. It was only issued a few weeks ago. And it gets to the issue of a number of things, partly a quote subjective condition and a quote pain case, as the judge referenced, and also the issue of IMEs and whether in fact IMEs should be used, or if they're not used, does that suggest something in terms of whether, even under the abuse of discretion standard, the court is going to find for a claimant. So next slide, please. So is this case, the Lewis case, indicative of a trend or an outlier? I think it's a little of both. And we're going to look at some cases, I think, in the next few slides that will help us understand that. As I said, I think it's a trend in terms of the use of IMEs or lack thereof being a sign of an abuse of discretion, but also somewhat of an outlier in that this case seemed to be largely driven by a senior judge making an attempt at some new law, and then of course the Third Circuit sort of level setting things a bit when it was appealed. So it's a little bit of both. Next slide, please. So new theories and trends is going to be our next topic, which is going to be a bleed over from our prior topic. Next slide, please. So in this, oops, sorry, my computer just timed out on me. There we go. Okay, sorry, I haven't moved enough in the last 40 minutes. Being the last person on, you get your computer to time out on you, but I'm back. So the last theories and trends that we're going to look at are mental illness and long-term disability claims, combined with a trend of the lack of an IME being something that the court has focused on in reaching decisions that are not always favorable to insurers. So the Whetstone case out of Ohio, this involved a truck driver, somebody who operated a large 18-wheel tractor trailers throughout the country. And the plaintiff focused on the fact that there were regulations governing his ability to perform his job, and that he had specific stressors related to his anxiety, which were worsened after he had witnessed a collision with a bus that prevented him from performing his own occupation. Next slide. And the court agreed, and this quote I thought was interesting, where the court wrote, "Unlike cardiologists or orthopedists who can formulate medical opinions based on objective findings from objective tests, mental health care providers typically must rely on subjective symptoms," again, that word subjective, to treat their patients. Next slide. And again, something we saw in this case, the lack of an IME was deemed problematic. And the court wrote that the Sixth Circuit has held that file reviews are questionable as a basis for identifying whether an individual is disabled by mental illness. This is especially so when the plan administrator is relying on said reviews chooses to make adverse credibility findings. So again, a court, now we're in Ohio, we saw one in Pennsylvania with the Lewis case, focusing on the lack of an IME as being problematic. Next slide, please. Now we're going to move over to Michigan with the Berg case. And again, we're going to highlight two themes with this case. We have a plaintiff who is a white-collar professional, an anesthesiologist, and we're also going to hit on the theme of the lack of an IME being referenced in the decision. So in this case, Unum had contended that a psychological condition caused the disability, which would result in a claim that was capped at 12 months. And the plaintiff contended that her disability was due to a physical, not a psychological condition, which prevented her from working as an anesthesiologist. Next slide, please. And there were two things that the court ruled in this case. The court held that in order for the psychological condition or the mental illness condition to be the ultimate trigger and therefore getting the 12-month limitation, that it must be the but-for cause of the disability. The court also found for the plaintiff citing to a lack of an IME as part of its decision. Again, it's a very similar quote to what we saw in the prior case and in the Lewis case from Pennsylvania, talking again about subjective conditions and how difficult it is to assess those without an IME. Next slide, please. So this, moving away from the subjective and IME world, I'm going to hit on one final case before we see if we have a few minutes for some questions. I know we're short on time, but the issue in the AD&D space of overdoses. And this is the Yates case, which we had reported on in 2021, which was recently affirmed by the 8th Circuit. And this brings up a familiar scenario that I'm sure many of you who have dealt with accidental death and dismemberment claims have dealt with in the space of drug overdoses with the opioid epidemic. This is one that we've seen. This scenario is one that you see a lot. So in this case, the court ultimately affirmed summary judgment in favor of the plaintiff, and the plaintiff's late husband had died from a heroin overdose, which the defendant had alleged was not covered as an AD&D claim. They did ultimately pay the life claim, but it was precluded on the AD&D claim because of a self-inflicted injury exception. And the court has some really good, helpful language in this case that helps explain the factors they relied upon in terms of how to determine whether something is self-inflicted in the context of an inherently dangerous activity like shooting heroin or driving under the influence of alcohol were one of the other circumstances the court focused on. Next slide, please. One of the arguments that the court rejected was the argument from that the plaintiff's husband, who had been a longtime drug user, so this was not someone this was not his first time using heroin, certainly knew of the risks of using heroin, which was enough to make it fall under the intentionally self-inflicted injury. And the court disagreed, ultimately saying that even if the defendant's characterization of his drug use was correct, by attempting to apply the exclusion that only applies to intentional acts, the defendant was essentially trying to incorporate a reckless or negligent standard into what the intentionally self-inflicted injury exclusion was meant to include, and ultimately agreed with the plaintiff. Next slide, please. One other fact I want to mention, because this is part of the more recent history of this case, deals with the fact that this was only a $50,000 AD&D case. I believe Glenn Cantor was the plaintiff's counsel here, which some of you I suspect are familiar with. But even though it was a $50,000 AD&D case, the attorney's fees that were ultimately recovered were double. Plus they also requested and got their fees on appeal. So it wound up being an expensive case, despite it being a small claim. And with that, I've got 1 minute left, and I'm going to announce the last CLE code, which is 28312. Again, it's 28312. Next slide, please. I don't think we have time for questions, Amy. If we have any, I think we can certainly reach out to those who have asked us questions after, and we are happy to answer them. And we will follow up with all of you that have participated today And thank you for participating with us, and we'll be sure to get you CLE credit.
That's
Thank
right.
you so much, everyone.
Keep an eye out for an email follow-up. It's going to include the link to the program materials and to the survey, which is important for the CLE credit. And like Caitlin said, if you have any questions or are interested in discussing any of these topics further, please don't hesitate to reach out to Caitlin, to Mike, or to myself. We sincerely appreciate your participation, and we hope you have a great day and a great Thanksgiving holiday next week. Thank you.
Thanks, everyone.